distill to everybody, I think is really important, is that an impasse is not a failed mediation. And every mediator will tell you that. And it's not just lip service. You will learn things if you have a well-conducted mediation. You will learn what's truly disputed. You'll figure out if somebody has a real appetite for litigation. You'll figure out if there's external factors that might be driving the case that are beyond the four corners of the evidence. And we'll talk some more about that later on, because cases don't resolve because of the facts and the law. They resolve for a whole host of other reasons. And your job in the mediation is to figure out what are some of the other pressure points for the other side and see if you can leverage those and maximize your recovery or minimize your exposure, as the case may be. Okay, so what are the challenges in the path to improving mediation advocacy? Well, I think partly because I don't think mediation is held in high regard. I mean, trial lawyers are celebrated. If I ask you who are the great trial lawyers, you'll know those in your jurisdiction. You'll know those because they have buildings named after them and courthouses named after them. But name a great mediation advocate, and I think you'd be scratching your head and you go, I don't know, that's not even a thing. That's like not even a thing, right? Like mediation advocate of the year. We don't even have that. Why don't we have that? Why don't we celebrate that? I mean, nobody comes back from a cocktail party and says, geez, I slayed it today at mediation, but they'll brag like crazy about their defense verdict or their big recovery if they're a plaintiff. We don't view mediation in the same light. That's really kind of pathetic, because mediation confers benefits at a very high rate, a very efficient rate, low cost, high reward, and it's also an emotional outlet for litigants, which is very important. We tend to forget that litigation quiets people. Litigation stifles people because you're not allowed to talk to the other side. And then we come to mediation, and what's the one thing we do in mediation? We just talk. That's all. Think about the enormity of that for a second. All we do in mediation is get everybody in a room or a virtual room, and we talk for several hours with a neutral, and the case goes away 70 to 80% of the time. I don't know why. I mean, I think that's amazing. I mean, maybe other people don't share that level of amazement, but we don't use any slick technology. We don't do anything fancy. We don't even have to have high-powered experts in the room. All we have to do is get all the people with the most knowledge of the problem in the room with a neutral, and the problem goes away in 4 or 5, 6 hours, as opposed to door number 2. Like if you've litigated construction cases that go on forever, and you might even have 2 or 3 or 4 mediations in a single case. I mean, door number 2 trial is incredibly expensive, time-consuming, stressful. Mediation offers complete resolution within 5, 6, 7, 8 hours. That's amazing to me. So why don't we celebrate mediation advocacy? I don't know why. I don't know. It's a cultural thing. I guess, trial lawyers are like fighter pilots or something, and I guess mediation advocates are maybe like the folks that load up the cargo. I'm not exactly sure, but they don't get celebrated. So we kind of got to change our perspective on how important mediation is in the scheme of things. If we didn't resolve 70 or 80% of the cases through mediation, our court system would be a bigger mess than it is already. All right. Let's real quickly talk about, and Stephen, please feel free to jump in if you disagree. When you disagree, it makes it even more entertaining. So feel free to do that, because to be sure I can get it wrong. Quick thing on mediation timing and mediation selection. You got to think carefully about who your mediator should be for your case. I do believe in subject matter jurisdiction. There's some mediators who will tell you subject matter competence, not jurisdiction, subject matter competence. And I think it's pretty important, particularly in the hard case. In easy cases, it doesn't matter so much. But when you're in the woods on a trademark case, or you got a construction problem, or you got somebody arguing some coverage exclusion, I think subject matter competence really matters. I think gender matters. I think race matters. I think age matters. You got to think about who's going to be in the room and who's the best advocate for what we're trying to accomplish. And here's a little secret that I learned early in my career. I don't pick the mediator I want. I pick the mediator the other side wants. Because if I'm delivering, let's say I'm a defendant and I've got X amount of dollars I can spend, I want the mediator to be respected and trusted in the other side. It's more important that the other side respect and trust the mediator than for me to respect and trust the mediator. Because at the end of the day, if I'm delivering cash and this is all I've got, I need the mediator to be able to sell that money in the other room as best as he or she can. And if the other side's a little leery of my mediator, they may not believe that. And so sponsorship theory says you want the private mediator that the other side wants. The only caveat to that being, if you know that mediator is not going to push very hard, then you got to think twice about whether you want that individual. And some people are pushers and some people are friends. I'm a pusher. I'm not a friend. I'm a pusher. And that's the way I was trained. That's the way I mediate, and typically tends to be pretty helpful in the harder cases. Anybody can mediate an easy case, but it's the harder cases where you got to really think carefully about who's mediating your case, who can carry your message, and then who are the personalities? Are they are they big personalities? Are they quiet? Are they meek? Are they going to be kind of narcissist in the room? Are you dealing with timid, quiet, middle-aged woman? Are you dealing with some, principal of a big construction company? Or who are you dealing with? So think carefully about who you got in the room, and then think about, does that mediator make sense in that room with those folks? Timing of mediation, I think, is one thing that's really not optimized. Optimized is the word I like to use a lot. That's an engineering term. It means make it mo better. Make it mo better. Timing is too late in most situations because the trial orders and the case management orders put the mediation deadline typically at the end of the discovery period, or so many days or weeks before trial. And that's a horrendous mistake. It's been going on this way for decades in the state of Florida, and I've written and spoken about this for quite some time, and I've been working with the judiciary in Florida to try to change this. Mediation needs to occur in most cases. Again, this isn't one-size-fits-all commentary, but mediation needs to occur about 90 to 120 days after joinder of all parties. It doesn't occur early in the life of a case for a couple of reasons. One, because the case management orders are written poorly and they put the mediation deadline at the end of the case. That's just been that way for 30 or 40 years. Do you know why mediation deadlines are put at the end of the case? Is there any science that says you should put mediation deadlines at the end of discovery? Are there any studies that show that late mediation is better than early mediation? No, none of that's true. There's absolutely no science, no math, and no public policy to support late mediation deadlines. They are historical anachronism. And the reason they exist is because when mediation was adopted in Florida and other places in the 1980s, there was a lot of objection to mediation conceptually. In other words, people were fearful of it because lawyers trained with a traditional legal education didn't necessarily know what mediation was or how you're supposed to perform. And mediation is sort of unlawyerly. It does not require traditional lawyering skills, the application of law, fact to law, preservation of evidence, presentation of experts. Mediation doesn't turn on the same axis as trial practice. And so when the judges adopted mediation in the 1980s in Florida, they put mediation at the end of the discovery period because they didn't know any better. They didn't want to be front and center within the first 60 or 90 days because what they were worried about was objections. It was a psychological ploy to deflect early objectors back in the 1980s. It's the same reason why, if you look in the rules of civil procedure, you'll find in the mediation rules a motion to dispense with mediation because they wanted to give the objectors an escape hatch. Almost nobody files a motion to dispense with mediation anymore. And if you ask a judge to dispense with mediation, they're going to look at you and you better have a darn good reason why, because it's almost a silly motion. I mean, it's almost silly now. It didn't used to be 40 years ago, but now it's silly. Mediation culture has evolved, all right, significantly, but our practices have. We have institutionalized late mediations for way, way, way too long, and it's just unexamined habit and custom. There is no science behind it. There is no logic behind it. There is no math behind it. There's no public policy behind it. It is a bad practice. But guess what? It goes on just about everywhere, except that there are a few corporations now that have recognized that corporations have, large institutional business like insurance companies who say, we're going to have early mediation mandate. We're going to put cases into mediation within 90 to 120 days. People say, whoa, I don't have enough information. Yes, you do. Yes, you do. A competent, experienced lawyer can handicap a case with not a whole lot of information pretty early on. You can see where the outer markets are. You don't need all the expert testimony. You don't even need to take the plaintiff's deposition. Classic example, wrongful death case with a dead baby who drowned in a pool. I don't need to take the parent's deposition a year from now to mediate that case. I can mediate that case within 60 to 90 days. What am I going to hear at the plaintiff's deposition is going to change my evaluation of the case? Not very much. Yet we wait months and years to take a deposition, and then you have hard feelings, you have litigation animosity builds up, makes the case harder to resolve. So what I did when I left a large firm with about 500 lawyers, and I was the mediation trainer for that law firm. We operated in about 6 or 7 different states. And at the end of my tenure there, I told all the lawyers, I said, get all these cases into mediation within 90 to 120 days after joinder of all parties. Even if you don't settle the case, and chances are you will, but even if you don't, you're going to learn a whole lot about your case very quickly. You're going to be able to size up opposing counsel, get your eyeballs on the other side. You're going to learn what issues are really disputed, what you don't know. Maybe there's some other coverage out there you overlooked. Maybe there's some causes of action or some defenses you forgot about or you didn't really appreciate. Maybe there's joinder of another party that needs to happen. There's a whole slew of things that you can learn in mediation as a result of an impasse. So don't view impasse as a failure. My good friend Jeff Deary said one time, he said, mediation has different grades. There's A's, B's, C's. It's not a pass-fail. You can have a B or C mediation. It's still a pretty good grade for a mediation. A BB plus mediation could still happen even if you don't settle the case. So don't be afraid of early mediation. People are against it because they don't know that they're just not used to doing it. But once you get to early mediation, you'll realize you have to share some information a little more quickly. You have to share some information informally sometimes, but you don't need a lot of formal discovery to engage in mediation. We only engage in formal discovery and a lot of it because the mediation deadlines are typically at the end of the discovery period. And so sort of by de facto custom and practice, lawyers don't push the mediation date forward on the calendar. They kind of default to whatever it says in the trial order. And so if the trial order says mediation deadline is November 1, you'll probably put mediation in September or October when you really should put mediation in March or April. You don't need to wait. It's a big mistake because you can learn a lot of information very quickly if you are mediating early. So that's the argument for early mediation. Attendance issues, real quickly on that. You know, in Florida, we have this funky rule in state court. You got to file a certificate that says the person's coming with authority. A couple things on that. If you're a plaintiff, I like to have the lawyer with the plaintiff in the same room. Sometimes the plaintiff and the defendant, or the defendant with the lawyer in the same room, even though they're appearing by Zoom. Sometimes it's easy to get client control if you have your client with you in the room, if client control is an issue. The other thing you have to be mindful, of course, is if you're appearing by Zoom, make sure you know who's in the room, who's in the background. Sometimes you'll have people appearing from I had a guy show up in mediation. He was working the cash register at a 7-Eleven. I kid you not. He was on duty to 7-Eleven and trying to appear at mediation. I said, that's not going to work. He ended up going back in the frozen food, or back in the cooler behind the counter in the 7-Eleven to do the mediation. Because I said, well, maybe you got a little confidentiality problem if you're doing the mediation at the front desk there. And so that was a little sloppy. So we fixed that. I do have an article online called The Convention of the Witch and the Princess, where I talk about the importance of appearance, lighting, background in your Zoom mediations. People who come into Zoom mediation with suboptimal lighting, bad camera angles, put themselves and their client at a disadvantage because the mediator doesn't want to talk to you, doesn't want to hang out with you, and doesn't want to help you. It's psychologically hurtful to the mediator if I have to peer at you at a funny angle or I have to have bad lighting. It puts me in a negative mindset toward you. You want to be the best looking attendee in the Zoom mediation. Since we're probably going to be stuck with Zoom mediations going forward, you need to optimize that. That means good audio. I can't tell you how many times I hear bad audio through the Zoom that's totally fixable. I mean, I operate my audio off a very simple, what is this, a Microsoft, what do you call the thing, 8? It's just a little, what do you call it, Surface 8. It's very inexpensive, but it has good audio and good video. And I've been very successful with that. So make sure your audio and video and lighting is top notch, because no one's going to predict. Most people are predicting that Zoom mediation is here to stay. It's quieter, it's safer, it's cheaper, it's more efficient. You can get people together from all over the country. So I don't think it's going to disappear. I think somewhere between 80 and 90% of the mediations are probably going to continue to be by Zoom. Okay, a couple other things I want to talk about. Multi-party cases present some real challenges in mediation. This is an area where I think lawyers need to do more work. First of all, plaintiffs have to give every defendant a reason to settle, whether it's a construction case, a med-mal case, it's a products case, or a premises case with multiple defendants. Typically, what can happen is that the plaintiff loses sight of one or two defendants and focuses on a target. And then they come to mediation, they wonder why the other minor defendants are not participating, because you haven't done anything to create any heat. You haven't done anything to put any pressure on them. You haven't given them a reason to settle. And then you come to mediation, you go, why aren't they contributing 20 or 30 or 40% to the pie? Because you didn't do anything to tell them that they needed to do that. You've been focusing on target defendant A. And so when you come to mediation, the other folks have already had their expectations set by your lack of attention to them. So you've got to put some ants in everybody's basket before the mediation. If in a multi-defendant case, intra-defendant communication is routinely lacking. It's one of my big sources of frustration. Is as a mediator, I will say to the defendants after the opening session, I'll put them all in one room and I'll say, have you all talked to each other before today? And invariably the answer is no. Well, why is that? You knew you were going to have to talk to each other to get this thing resolved. Why didn't you have an intra-defendant meeting before mediation? I will tell you the answer. It's the same answer, the reason why we have late mediation. It's unexamined habit and ritual, because there's nothing in the case management order that currently exists that says ye defendants shall meet 20 days before mediation to discuss intra-defendant funding arrangements, proportional shares, coverage issues, etc. Nothing in the case management order that tells you to do it so it doesn't get done. And I know that because I did this for 30 years. And the only time we had intra-defendant meetings is when I asked for one. And that's usually because I was the target and I was looking for contribution from other folks because I knew I was in trouble. So I had to initiate that. But nobody ever called me during my career and said, Henry, let's set up a intra-defendant meeting ahead of time to figure out sort of where everybody's going to be, because you don't want to show up at mediation and find out that this defendant who you're anticipating was going to contribute now says, no, I'm not paying any money. Well, that doesn't work for me. Well, you know, that's kind of a dumb position. And now I don't have an opportunity to educate you. I don't have an opportunity to beat up on you. I don't have an opportunity to move the needle because I didn't know what your position was going to be until the day of mediation. But if you tell me 30 days before mediation, I don't think, you know, I'm going to pay any money, Dave. Well, then I can do something with that. I can work that problem. Right? In advance. I can go to the plaintiff's attorney. I can say, hey, co-defendant B is not going to pay anything. I think it's going to queer your chances of settlement. And the plaintiff's attorney thanks me for the information. I haven't given away any trial secrets. I haven't given away any strategy. I just shared my impression of what the other parties are going to do, and the plaintiff thanks me for it. Now I have favored nation status with the plaintiff because I read it out to the non-paying defendant. You see the advantages of that immediately? I put myself in a more favorable, equitable position in the eyes of the plaintiff by reporting to him that his lack of attention to defendant B is queering the possibility of settlement. It's so, and how long did it take me? One phone call. It's one phone call. And all of a sudden I got a whole heap of information. And now I can tell my client, my carrier, whoever I need to tell, hey, I think we got a problem with defendant B or defendant C. And then we have to strategize and figure out what we need to do to change the dynamic so we can get money on the table from them, right?
So David, if you're trying to move these mediations forward, so how do you go about to get the other side to agree to move it forward?
Well, you have to sell them on the process. You have to sell them on the idea that we don't need to spend $100,000 in discovery. It's just make it hard to settle the case. We need to get in early to find out what we don't know, what the plaintiff will take cheap early money. The best settlements are going to come early. So the argument is the default should be early mediation. We can exchange some basic information, get our arms around the damages, get in there and give ourselves and our client an opportunity to settle out early. Most clients want that. So if I go to the co-defendants and I say, hey, tell your clients we're going to have an early mediation, what's the pushback going to be? What the cost of it? I mean, the cost of that is less than a deposition. So it should be a pretty easy sell. But you're right, Stephen. I sometimes see resistance to it. I see resistance to early mediation. And not the plaintiffs, particularly contingency fee plaintiffs. They're all too happy to go to early mediation because their effective hourly rate goes through the roof if they can settle the case early. That's not usually where the problem is. Okay. Sometimes the problem is with the plaintiff who's an hourly fee business lawyer and he wants to milk the file for 6 months or a year. Then I know I got to shut that down. I know I got to shut that down because I can't tell you how many times I mediate a case where the settlement value is under 6 figures and the guys have already pumped $40,000 or $50,000 into the case. Now it makes it really hard to settle. Makes it really hard. And I have this monthly. Monthly, I have this problem that the over lawyering of the file has created a huge problem for the clients. And then they have some cost issues. It's just a train wreck. Right. So if you really want, the most altruistic thing you can do as a lawyer is get the case into early mediation because your client will thank you. Your client will thank you. And then if he doesn't settle, then the bills come and they can't really complain, right? I gave you the opportunity to settle the case. Now I got to bill you for my time. Right now the bills are coming. Okay. As opposed to bill you for a year, then go to mediation and find out if you're the plaintiff in a commercial case, your case is only worth $100,000, but you already spent $50,000 litigating it. What? How does that make any sense? The math doesn't make any sense. Early mediation is the way to go. I'm pushing for it to happen by court order because it hasn't happened organically. It hasn't happened sort of, as a matter of evolution in our culture. Our culture's stuck because the case management orders are the same, and the case management orders don't order early mediation. So we have this back-ended, back-weighted process that's suboptimal. That's just the reality where we are. Okay, a couple other things that I think everyone should do. Most mediation orders will say you got to send a submittal to the mediator. Don't send me a submittal. Send the submittal to the other side. You want to educate the other side on what the problems are in their case in writing, and then the lawyer will share that with the client, and the client will then say, okay, I didn't know these were the problems in my case. I didn't know these were the issues. I didn't know this was my exposure. I didn't know it was going to take 2 years to litigate. I didn't know we had coverage problems. So the submittal that you send to the other side is one of the most important documents in the process, because you're going to introduce themes and ideas and concepts and arguments and bullet points, and then you're going to reiterate those, and the mediator is going to reiterate those during the mediation. But you want to set those themes afloat well before you get to mediation. You don't want these people to hear these things for the first time, because it takes a while for these truths to set in. People aren't going to accept adverse truth immediately. But if you send them a position statement 2 or 3 weeks before, and then the mediator repeats it, and the lawyer repeats those truths in opening, and then the mediator harks back on some of those themes during the caucuses, after a while, the plaintiff starts to realize, or the defense starts to realize, hey, there's another reality here I need to consider. You're trying to persuade the other side to get to a place where you want them to be, and the persuasion starts before you get to mediation, not during mediation. You got to persuade them early on that there's another reality, there's another potential side of this thing. And time is always the plaintiff's kryptonite. You can always use no matter how bad your case is, the fact is time is the plaintiff's kryptonite. And if you explain to them very simply and courteously that this is going to take a long time to resolve, oftentimes they will think twice about, turning down your money. I can't tell you how many times I use time as a weapon to get the plaintiffs to settle. And for the defense, the plaintiff's weapon is, this case is only going to get worse for you. How does it get better? How is investing more money in this file going to make this thing really turn around? And so there are things you can introduce in a position statement that will yield benefits during the mediation statement. I had a plaintiff's attorney tell me once, he says, David, I love when I get a position statement from the defense, because I can tell my client then, hey, this is what they're going to say. I don't have to be the bad guy. I don't have to be the one beating up on my own client. I can just read them the position statement and say, these are all the things they're going to say about you and about the case. And and I get client control that way. So you're giving the plaintiff's attorney a mechanism for achieving client control when you write a submittal. And if you're on the defense side, typically you get paid by the hour, so you get paid to write the letter. You get paid to write the letter. Why wouldn't you want to write the letter if you get paid to do it? So it's really important that you write to the other side. Don't write to me. You can copy me on what you say to the other side. There's an article on my website called the 10 Dirty Words. There's 10 dirty words you don't use in a pre-mediation submittal during mediation. Words like frivolous and specious and sanctions. Those are words that aren't going to move the needle at all. In fact, they just upset the other side, and you shouldn't use those. It's like based on George Carlin's, what did he have? 8 dirty words, 7 dirty words, something like that. There's 10 dirty words you can't use in mediation. You can find that blog on my website if you're interested, but don't use those dirty words in a position statement or in your opening session. If you call somebody's position frivolous or specious, all you're doing is really accusing the lawyer of unethical activity. And that's not going to sit well in the other room. It doesn't help you resolve the case to say somebody's position is frivolous. With most things in mediation, word choice is really important. You could say, I think you're going to have a hard time proving that. I'm not sure that position is well taken. I think that's a pretty big uphill battle for you. All those are very nice ways of saying exactly the same thing without the moral with the moral overlay or the moral tinge to those kind of comments. Okay, preparing the contingency fee client, we talked a little bit about that. You want to get the defense summary in your hands 2 to 3 weeks before so you can have a conversation with your client. You want to draft a mock closing statement with a range of settlement figures so the client gets some sense of what the recovery might look like. Because oftentimes they forget they got to pay for liens, they got to pay for costs, they got to pay the fee, et cetera. Defendants need to do different things. We need to send a letter to the other side, explain the mediation process. I have a standard letter for that if you want to use it. It's just sort of a one size fits all thing that tells you what is a mediation. I send it to everybody, no matter how sophisticated or how, what their station in life is. Here's one thing I found interesting. Oftentimes, very sophisticated people, even like doctors or, folks who are successful business people, they don't know what mediation really is because they've never been to one. They don't really understand what goes on because they're not on television or the movies. They don't know. They might confuse it with arbitration. They might think they don't know what the role of the mediator necessarily is. So my position statement, my little letter that goes to the client explains all that. And I find it highly useful because I don't have to reiterate everything for half an hour. I just send them a little letter, a little memo and says, here's what a mediation is. And it goes out to everybody. I mean, I cannot tell you how many times I've been astonished to find very sophisticated people with advanced degrees entirely clueless about mediation and how it works because they've never been there before. So it's really important that you educate your client about the process. Okay, and then we talked about dressing appropriately, even for Zoom. I think that's kind of, I mean, if you're a plaintiff and you're trying to get a good recovery and you show up in a t-shirt and a pair of cutoffs, do you really care about your case? I mean, what message are you saying to me as the mediator? How hard do I really want to work for you? I'll work as hard for you as you want me to work for you. But when you show up with that speaks to me a level of indifference about your claim and a lack of attention to detail by your lawyer. And that's sort of like dialing it in. And I'm not really keen on working for somebody that hard to dial it in. You see, it's messaging, it's subliminal messaging. It's really kind of important beyond just the words. How do you look? How do you appear during the mediation? Kind of important, I think. You disagree, Stephen, or no?
No, I think it's important. I think, unfortunately, a lot of times, especially on the plaintiff side, they don't really see the value of that, and right. They're normally comfortable looking like they do in t-shirts and shorts and that kind of thing. But yeah, I agree. I think it's put your best foot forward just for that one time, and it'll pay dividends.
Yeah, I think we got lazy with Zoom because it was so much fun not having to put on pants, right?
Right.
I mean, that was right. I mean, sitting in your pajamas is fun, but we can't do. We got to think a little differently. At least from the top up, you got to be thinking about what you look like, right? Okay. So preparing the client for the mediation. I think we talked about that. I think you got to discuss with them the disruption in their lives. That's the thing I use as a tool all the time as a mediator. Is the litigants, unless they're very sophisticated and they've been down this road before, they don't appreciate how much the mediation is going to disrupt their personal lives. I mean, the classic example that I'm familiar with is, the doctor in the Med Mal case. He or she's all willing to defend. They got experts behind them. They're all gung-ho to defend the case. Didn't violate the standard of care. I did a good job for the patient. And then you tell them you got to sit in a courtroom in Marion County for 2 weeks and cancel all your patients or your surgeries. And it's like, what? 2 weeks? What? I got to be there the whole time? Well, yeah, you pretty much got to be there the whole time because it doesn't look good if you're not. Oh, I didn't realize that. Now maybe we should think about settlement. I can't tell you how many times I had a case settle. We were like $50,000 apart, and he was a pretty sophisticated businessman. I think it was like a broker kind of guy. It was one of these investor malpractice kind of things. And he was in a pretty good defense position, was going to put a little bit of money on the table, but not enough to close the deal. They're about $50,000 apart. And we were mediating, it's like March, I guess that's March. Yeah, we were meeting in March, and there was a federal trial date in May. And we were about ready to impasse the case because we couldn't get enough money out of the defense. And I said to the defendant, I said, so-and-so, I said, what are you doing in May during the trial period? He goes, what do you mean? He goes, well, what are you doing? You're going to trial. I'm like, yeah. Well, what do you got going on in May? He goes, well, my daughter's graduating from Brandeis. I go, what? I go, yeah, isn't that during the trial period? He goes, oh yeah. Oh yeah. And then he realized, oh yeah. And I said, you going to call your wife and tell her you're not coming to your daughter's graduation because you're in Middle District Court and trial? I need another $25,000, sir, or you're not going to your daughter's graduation, because I don't think the grant continuances for, graduation in Brandeis is not grounds for continuance in the Middle District. And he looked at me like, and he looked at his lawyer, and the lawyer started shaking his head and started laughing. And he goes, yeah, you're going to miss the graduation. And he goes, okay, how much more money do you need? And now I got you. So I always look at what is going to be the disruption in the person's life. And that if that's disruption is significant, I can sometimes coax some money out. Or you have plaintiffs who have kids with special needs or elderly parents or something like that. And they literally cannot go to trial. That it would be incredibly difficult for them to go to trial. And you find that out in mediation. You're not going to find that out through answers to interrogatories or requests for production or even deposition, because hardly anybody asks, oh, by the way, do you have elderly parents that require you be at home most of the time or at least accessible? No, you don't ask that question, but it comes out in mediation all the time. You find out things that drive settlement that are outside the four corners of the case, and you're only going to find out about them when you get to mediation. So it's better that you find out about them early on rather than late, because I can use those pressure points to get the case resolved. That's the reality of mediation. It's not the facts and the law that drive settlement. Oftentimes it's other ancillary factors. Corporations that want to do a deal with another company, and they can't do the deal because they got this litigation hanging over their head. And so it's queering the acquisition or the merger. Or I got somebody who's trying to sell their property and they got an easement claim and they can't get out from under the easement claim and they can't sell their land, right? Or I've had homeowners associations that were crippled by no one could sell their house or their condo because they had this easement claim pending against the whole condominium association. And everybody in the condominium association was in an uproar because they couldn't move their house. They couldn't sell it. They couldn't get rid of it. So there's all those kinds of things that sometimes drive settlement you need to be mindful of. A couple of things on opening statements. Opening statements in mediation are important. Occasionally we will dispense with opening. My rule on that is the only time I dispense with joint session and opening is if there's really a lot of animosity and I think someone can't keep it together and they're going to blow up the mediation the first 30 seconds to a minute. That's pretty rare though. Just because you're uncomfortable, just because you don't like the other side, just because you'd rather not be there, that's not grounds for dispensing with opening in my mind. I want the people to be uncomfortable. I want them to say, I don't really want to be here. Right. That promotes settlement. That promotes settlement, because if you know you got to be with these people for the next 6 months or 9 months or a year and then see them in the courthouse for a week, people don't want that. So they're going to want to be motivated to settle the case. So discomfort is actually useful in the mediation process, a little bit of discomfort. Couple other things. Opening statement's really important if you're a defendant, because there are stereotypes about defendants and defense attorneys, how they're going to be and how they're going to appear. And if you come across as a genuine, concerned, at least somewhat empathetic individual, that's going to pay dividends in the other room, because the expectations are going to be formed by what people see in TV and movies. And they think you're going to be snarky and cold and insulting and rude and disparaging. That's what they expect is coming. And if you're not that, and you are respectful of the plaintiff, particularly a personal injury plaintiff, if they've lied in their interrogatory answers, if they're a malingerer, the last thing you do is you call a malingerer a malingerer. You don't ever do that. And they're a fraud. You don't call them a fraud. They already know that. I had a plaintiff's attorney tell me something early in my career that I thought was really useful. I was mediating a case and he came, and the defense did a really good job in opening. The plaintiff was a really troubled plaintiff. I mean, lots to talk about, a lot of problems, misreps on answers to interrogatories, prior medical that wasn't disclosed, blah, blah, blah. So, but the defense lawyer didn't go into any of that. He was very diplomatic. He talked about how much he wanted to resolve the case, talked about how much I know it must have hurt, how much pain you must be in. Didn't go into any of the prior fabrications or inconsistencies, didn't do a cross-examination of any sort. And then we got into the private caucus, and the plaintiff's attorney thanked me. He said, David, you have to thank the defense attorney, because you don't know how easy he just made my job. Because I thought I was going to have to peel my client off the ceiling because the defendant was going to chew him up. And that didn't happen. It makes my life so much easier. And I always remembered that story. You don't want to put the plaintiff on the ceiling, because then I got to pull him off the ceiling to get him to resolve the case. So the best openings on the defense side are often respectful. They're impactful, but they're respectful. They acknowledge the pain or the injury or the accident at some level. And then they urge resolution. I even got to the point at the end of my career where I would tell the plaintiff, we're going to pay you some money today. We're going to pay you some money today. It's probably, and I'll tell you up front, it's probably not going to be all the money you and your lawyer want. I'll be honest with you. It's probably not going to be. It's probably not going to be the most amount of money you could ever get. The most amount of money you could ever get would probably be a trial. You're not going to get that kind of recovery day, but I think we're going to give you enough money to be satisfied, and hopefully enough that will satisfy you and your attorney. I don't know what that number is going to be, but I think we can get to a deal. Something along those lines is what I said at the end of my career. Early in my career, I did a cross-examination, told them all the ways that they lied and how they misrepresented, and I read them my summary judgment argument. Nobody thinks they're going to get summary judgment entered against them. No plaintiff ever thought that. So saying you're going to get summary judgment entered against them doesn't mean anything to them, because surely their lawyer is not so incompetent as to be, subject to a potential summary judgment motion. Because then you're telling me my lawyer doesn't know what he or she's doing, and I can't compute that. So saying summary judgment or saying attorney's fees, we're going to get attorney's fees against you, unless you're dealing with a very, very sophisticated set of characters on both sides of the V, those kind of arguments really don't go very far. So I would urge you to think much more positively. My old boss used to say, you get more flies with honey than you do with vinegar. And I always remember that. I think that's a pretty good line. Okay, so it's not oral argument. It's not summary judgment motion. It's a plea to get the case resolved, and some demonstrable level of empathy needs to be articulated during the, and apologies are huge. We could do a whole thing on apologies. Apologies are really important because what it does, and you can do the pseudo apologies, you can craft the language, but I can't tell you how many times a plaintiff has told me if they would just apologize, and if you get that out, and it's got to be from the client, it can't be from the lawyer, it's got to come from the client, because it means something when it comes from the client. If it's just from the lawyer, you're just a mouthpiece. It's not authentic. You gotta practice it. You gotta deliver it. You gotta kind of pretend like you mean it, even if you don't. And because it has value in the other room to the plaintiff side. I don't know why we don't use apologies, because they're free. They don't cost anything, and they're really useful. Now you got to make sure you practice it. I had a doctor one time that was giving an apology, and the apology turned into an accusation against the plaintiff and went, oh, horribly wrong, horribly wrong. It was a train wreck. And I had to, I didn't have my steel-toed boot, but I wish I did. And it went horribly wrong. So now I learned a lesson, which is you got to rehearse the apology, and you got to literally listen to what the client's going to say ahead of time and practice it and tell them, this is what you're going to say, right, right, right. Don't change, don't go off script, don't change your message, no matter what you hear. This is the message, right, right, right. So I didn't do that. I didn't practice with the doctor. I just said, we got to think about an apology. And then what he delivered was not good. Not good. Okay, let's go to a couple of things on mediation ethics, just to fill our ethics component here. Make sure when you leave mediation, you don't have an agreement to agree. If you have a term sheet that requires the parties execute another document that resolves the case, like a longer form settlement agreement or a release, you potentially have what's called an agreement to agree. And mediators will differ on that. They will. Most mediators don't know the case law. The case law says if you have a document that contemplates the execution of another document, and that other document has to be mutually agreed, it's not some perfunctory thing like a quitclaim deed or a conveyance or something. If it's actually a document that has to be negotiated and signed, then the deal doesn't get done until the second document is negotiated and signed, right? The first document is just an agreement to agree. So those Friday afternoon quickie mediation documents that you sign, they say, well, we're going to sign another document later on. Well, technically, you have potentially what's called an agreement to agree, and it's not an enforceable deal. So the lesson is to bring your settlement terms with you to the mediation so we can crank out the settlement documents on the fly and not worry about that problem. It only blows up like 1 out of every 100 cases, but it doesn't blow up with me because I make sure everybody understands that if you have an agreement to agree, you don't have a deal until the second piece of paper is done. People don't like that, but that's the law. Make sure you can't misrepresent facts or law in the mediation. You think, well, it's confidential and privileged, I can say anything. Not true. If you tell somebody I have an expert who's going to testify to blah, 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 and you don't have that expert, that's a misrepresentation. It's actionable. It's an ethics violation. Ethics violations during mediation, by the way, are not subsumed within the mediation privilege. So if you engage in unethical conduct or make unethical statements during the mediation, that's an exception to confidentiality under Chapter 44.405. So it's not protected. Neither is legal malpractice, by the way. Okay. The other kind of malpractice we see is when you have a lawyer representing 2 or more plaintiffs over a finite pool of money. That's a pretty big problem. And then failure to investigate coverage and failure to investigate confidentiality and privilege issues when you mediate out of state. Do not assume, and I have articles on all these things on my website. Don't assume that the laws are the same in the state where you go. Some states have some wacky mediation rules, like good faith requirements and things like that, where they can report certain conduct to the judge. You got to be very careful when you mediate out of state because you don't know what you're necessarily going to run into. Okay. We're stuck. What are we going to do? How do we get more information before declaring impasse? I circle back. If I think I'm heading toward the impasse, I circle back and I go, let's kind of reshuffle the deck here. Why don't we want to settle this case? Why don't we? What would happen if we don't settle this case? What's going to happen next? And I make sure that clients really understand in a very clear and specific way what is going to happen to them. What is their life going to be like for the next 6 months, a year and a half, 2 years, if we don't resolve this case? Because I don't think lawyers, I know I didn't when I was in practice, I didn't spend a lot of time telling my client what the next 6 months or a year and a half is going to look like. I really didn't do that very well. I can tell you that honestly. I didn't do, and I don't think many lawyers really get into the weeds on that. This can be very disruptive. You're going to be deposed. Your husband's going to be deposed. Your kids, your adult kids, they might be deposed. Your boss is going to be deposed potentially. Your coworkers might be deposed. Your parents might be deposed. You know, they're going to ask for all kinds of medical records from you. You're going to have to wait a year and a half for a trial date. You're going to be living with this problem for a long time. And then it might not even end. Then it might go on. If there's a really big verdict in your favor, the defense might be motivated to take an appeal. And I can tell you that nobody talks about appellate risk. Nobody talks about appellate risk. I was a law clerk at the 5th District Court of Appeals, so I come at cases a little weirdly. I always look at appellate risk first. If this case was to go to trial or be resolved by summary judgment, is somebody likely to take an appeal? And if that's the case, you got to factor that into your analysis because, you know, you're looking at 2024, 2025 money potentially if there's an appeal. And I think appeals are something that people got to keep in mind because it gives you a leverage point. The plaintiff says, well, I can bust through the policy limit of $1 million. I can get $1.5 million verdict. And I say, fine, you might be right. So you're not going to accept 600,000 or 700,000. No, I want the policy limits because I know I can get more if I go to trial. Okay, fine. And if you go to trial and you do get $1.5 million against the $1 million policy, what is going to happen next? They're going to have to take an appeal because the duty to defend in Florida includes a duty to appeal. They can't just pay the $1 million and be done with the file. They have to appeal on behalf of their insured. So you force their hand if you get a judgment in excess of the policy. And the client hasn't heard that before. The client doesn't understand that. They don't know the law of bad faith. And then I start explaining, I said, so $700,000 doesn't look so bad, does it? Because anything north of $1 million is going to be an appeal. What you really want is a verdict around 800,000 or 900,000, because then the carrier can save a little money off the policy limit and they won't be motivated to take an appeal. The worst thing for you is a judgment in excess of the policy limits that they're going to appeal, potentially, if you want recovery early. In some respects, you're better off getting a verdict for 900,000. They're offering you 7. Changes the perspective on the case. If you think of, and the client's thinking, well, how long do I got to wait for my money? Right. So be careful about appellate risk. It's a big deal. It's kind of a big deal. Okay. Now, if we get close to mediation, get close to settlement, but we can't quite get there, and we're going to run into a potential impasse, invariably the topic comes up of, well, from the defense, I'm going to file a proposal for settlement, or in a commercial case, both sides sometimes will file proposals for settlement, or the plaintiff will have already filed a proposal for settlement in a BI case. And then we have the issue of, okay, how much leverage is there really? If it's a judgment-proof client, nobody really cares about the PFS, but there are a whole host of plaintiffs who are not judgment-proof. They might be middle-income people, but they got some assets. And that's where I think proposals for settlement and insurance comes in. I actually was aware of this insurance about 20 years ago because the insurance was started, if I remember correctly, and Steve, you'll know, there was a guy in Florida who was a trial lawyer, it was Rich Kodolinski. Is that his name, or Kodoleski?
Yeah, Rick Kolodinsky, yeah.
Kolodinsky from, I think, Daytona Beach was the guy who sort of came up with this whole product. And so it started in Florida. I mean, I don't know how many states we have it in Florida and Georgia. Does anybody else sell it anywhere else? I don't know.
No, it's just, and it's the PFS statute's pretty unique. There's only maybe 6 or 7 states around the country that actually shift attorney's fees.
Right. So you have, so the reason I invited Steve is because this ties in neatly with what happens in the mediation process, which is we get to a situation where we're close to impasse. Now we got to think about what our PFS is going to be. and what's the potential impact for that? And can I get leverage for the PFS and what the insurance does, I guess, for the, and it's only available to plaintiffs, right, Steve?
No, it's actually available to both plaintiffs and defendants.
Oh, it is.
I
Okay.
would say our sales are heavily favored in terms of plaintiffs because they just don't have the financial wherewithal to handle a adverse fee award. But defendants that have large SIRs or defendants with assets with a low limit, like a OBGYN doctor with 250, 750 a limit, they have exposure potentially for PFS and have assets. So yeah, on the defense side, even we do have some discussion with carriers on the auto insurance side, in that some of the case law recently is making it that there's exposure for, in getting into potential bad faith context, exposure for the carriers, and some of the carriers are thinking about buying our product as basically reinsurance for their PFS risk.
Right. Now, it didn't used to be available to defendants, did it?
Yeah, it's always been available. It just hasn't been very popular.
I got it. Okay.
Yeah. So,
okay.
Right, because a lot of the insurance companies will just go ahead and pay it out, as part of the overall defense of the exposure policy. Yeah.
Right, but if you're a bear and you're a company with some assets,
absolutely,
that's your sweet spot, I guess, is your small to mid cap business that does have attachable assets that would get, and if they get whacked for $300,000 or $400,000 in fees, it's going to be a train wreck for them, right?
Correct. Yeah, and the issue is, it's like you said, it's been around for 10 years. Rick Kolodensky and I, he came up with the idea, and I was the insurance guy that actually convinced the carrier to write this kind of insurance. Right. And so in that process, it's kind of like a lot of people have heard about it, but actually haven't pulled the trigger on it. And I think it's, the analogy I always make is it's like you have your iPhone and it has like all these great features on it and it's available to you, but you never really quite take the time to figure out all the cool stuff it can do. So yeah, so that's what we do. We just kind of educate people and about what's the good, bad, the strengths, the weaknesses, all that kind of things about the product.
Right. So I guess, can you give them a little flavor of just sort of the underwriting issues or the timing issues?
Right. Yeah. So the pricing there is no case underwriting. It's all done dependent upon when you buy the product in the life of the case. If you buy it within 30 days of getting the PFS, the price is the cheapest level, which is 5% of the limit selected. So the coverage limit you're looking at is you're protecting against the amount of attorney's fees and costs that would be shifted if you don't get at least 75% of the PFS offer. So for $50,000 of coverage for that exposure, 5% is $2,500, plus there's some state taxes and fees and that kind of thing. If you don't buy it within the first 30 days of getting the PFS, you move up to 7.5% of the limit. And then when you get to 90 days prior to the start of trial, it jumps all the way up to 15% of the limit. And we've just seen through in the loss data through the years that, people are buying at that late in the case. It's, it's kind of like, your house is on fire and you are calling up to get homeowners insurance. And then actually, a PFS can be tendered as late as 45 days prior to the start of trial. At that point, we give you 5 days if you want our insurance. If you don't buy it within 40 days prior to the start of trial, you can't even get it. Our company, our insurance carrier says the risk is too high. So a lot of it is you have to kind of figure out when to buy it to balance the cost of the product relative to the risk of the product. Of course, if it's going to settle through mediation or any other way, you don't need our product. Our product only covers liability under the PFS statute, and that only kicks in when you actually go all the way to verdict. So, but it is nice to have. It does have a positive impact in mediation, because if you can take that exposure for your client off the table, then your value of the settlement can go up, and attorneys like using our product because the price of the product is less than the effect that it has on the settlement value going up. So yeah, it's people that are familiar with it really like it a lot, and we get rave reviews.
Good. So I guess the argument is, for the reason why you give them a break on the premium early is because your folks know from an underwriting and loss perspective that if people are buying late, they smell some problem with their case,
Correct.
and they
Right.
know that they subjectively appreciate that the risk may be now pretty significant, that they're not going to be able to beat the number, and so that you say they're coming on board when there's already smoke there in the file.
Correct. Exactly.
Okay, so
Yeah.
that's why. So that would
Right.
argue for having a mediation pretty early, because then you're not going to settle, and then you need to buy the insurance. Whereas if you don't want to buy theoretically, you don't want to buy the insurance and then go to mediation 2 weeks later,
Correct.
because then you will have wasted the money on the premium. So if you mediate early, you can't settle the case. Now the proposal for settlement comes, or both sides file proposals, and then you have an opportunity to buy your insurance at the most favorable rate. So that's another argument basically for early mediation.
Correct. Yeah. So you get a better feel of the case. And, we always tell people, if you think your case is going to settle, just hold off. Now, of course, the price may go up. You may trigger one, and it's not a gradual increase in price. The price, goes up, in these stair steps. So you'll see, right before, at the 90-day mark, people will start buying, or right after, when they get right near the end at the 40-day mark, then a lot of sales will happen. So people just kind of like time it that way.
I got you. Okay, well, that's helpful. And then you also now have a product that covers de novo, is that right?
Yeah. So non-binding arbitration. So in COVID days, attorneys were reaching out and they were like, the non-binding arbitration statute is worded almost exactly the same as 76879, the PFS statute. So we went to our carrier, which is Genstar. It's a Berkshire Hathaway A++ carrier, and those, we said, basically it's the same exposure with a little bit more exposure. And so if someone in an arbitration doesn't like the arbitration award, they request a trial de novo. There is a separate exposure under that statute, which is 44103. But again, it's basically the same as the PFS statute. So for an additional 1% of premium, we can add the exposure that your client faces under that statute as well, under the same policy. So for a minimal increase in premium, you get the protection if you don't get at least 75% of what you got at arbitration in the trial de novo. So once again, you just have to analyze, does my client have assets? Is there a chance we're going to trial? And one of the comments I was going to make earlier, David, is, in mediation, I think it's really important to drive settlement value if the threat of litigation is credible. So if the defendant knows you're going to settle this case just because you don't want to go to trial, or you don't have a whole lot of experience in going to trial and all that kind of thing, that's that I think drives a lot of the settlement value. So if you are, if you're going to trial, then you do have potentially a PFS risk if they've tendered a PFS on you. Again, it's all about perception at that point. And the existence of our product will enhance the perception. And also it gets your client, typically on the plaintiff side, but it gets for both sides, more comfortable with rolling the dice. Because often, I take a lot of these calls when people are calling about the product and want to learn more about it. Very, very consistently, and not surprisingly, they're like, my case is worth more than this, but I have this risk, which is my personal assets. It's personal liability under the PFS statute. So they can go after the personal assets of the litigant. Maybe I should just take it, but then my attorney told me about your product and blah, blah, blah. Yeah, that all that taken together drives settlement value, and then of course that drives contingency fees on the plaintiff side, because they get a larger percentage of the settlement and or judgment amount if they can drive that up further. It's in the plaintiff's attorney's best interest as well. And it's worth mentioning that we do have an ethics opinion. We got it way back in 2010 that the premium for our policy is considered a cost that can be advanced by the plaintiff's attorney.
Oh.
So the plaintiff's law firm can pay the $2,500 for the premium, count it as a cost that's recoverable out of the settlement or the judgment. So, so some attorneys will do that if the plaintiff doesn't have $2,500 laying around for this niche insurance product. Other attorneys will not front the money. They'll say if the plaintiff wants it, they got to pay for it themselves, and they can just put it on a credit card. All these kind of things. So there's kind of like a lot of little moving parts to it, but driving the settlement value up is really one of the purposes, especially on the plaintiff side of the product.
Mm-hmm. All right. Well, thanks. I appreciate that, because that's ties in nicely with what's happening across the state. Because I think there will be more non-binding arbitration case management orders, and so I would expect folks that's probably that's one of the major drivers of why people don't object to the confirmation of the award, because they're afraid of the potential outcome. And I don't think that's particularly fair. I don't think when you file a lawsuit, you should be subject to a non-consensual arbitration that you didn't ask for, you didn't want. If you wanted arbitration, you could have done that on your own ahead of time. Now the courts force you into arbitration, and then if you don't like the arbitration award from one neutral, which just seems sort of random, one random opinion from one neutral you don't like, now if you want to object, you run the risk of attorney's fees. It
Correct.
seems like, I mean, you're putting a pretty high price on a jury trial, right? I mean, I'm not saying it's unconstitutional, but it certainly puts a premium on the exercise of your right to a jury trial in a way that I don't think most people bargain for. So as you can see, I'm not a big fan of non-binding arbitration, but if you can buy the insurance and offset that risk, then I think it would encourage you to request de novo potentially. That's the advantage.
Yeah, and it's very very easy to get our product, but I think the other dynamic is a lot of plaintiff attorneys are hesitant to put a PFS on the defense, even though that could put more pressure on the defendant to enhance settlement value and therefore a settlement. And the reason why they don't do the PFS is they don't want a counter PFS coming against their client, which has, because typically the plaintiff doesn't have the same assets that the defendant does. Right. So, but our product allows you to mitigate that risk. So you put the PFS on the defense, right. And then if they counter PFS, then you don't have to have that as an uninsured risk.
All right. So there has to be a trial, because apparently there's an exclusion. If you get summary judgment entered against you and you get whacked for attorney's fees, the policy doesn't respond to that.
Correct. Right. Yeah. Okay. And it is, as it says, available in Florida and Georgia. Georgia has a very similar statute. It's not quite as ingrained in Georgia. I think it was maybe 10 years ago, the PFS statute came into play in Georgia. So we don't see as much up there, but it is available in those states. And of course, federal diversity cases using state law.
I'm curious, and you may not be able to answer this or even want to, but I'm interested just geographically, where do most of your policyholders come from?
It's funny. Most Tampa, I-4 up to Orlando, to Volusia, up to Jacksonville, all that kind of area seems to be historically most of our purchases, not as much down in South Florida. And just as an aside, one of our marketing pushes, we've been, advertising on LinkedIn and Facebook and that kind of thing. And one of the things we are really pushing is down in South Florida. And actually I have seen some more sales coming from Boca and West Palm and Miami and all those kind of things. So I don't know if that was, I don't know. it's,
you don't know why, you don't know
don't know why.
geographically why. Yeah, it's
Right, right.
that's interesting.
Yeah.
'Cause I would have thought just the opposite. I would have thought being all the difficulties of those southern counties that there would have been more there, but that's interesting. Okay, thanks for that, Stephen. I really appreciate
Thank
it.
you.
I
Yeah.
think that's helpful to folks that need to navigate these issues and the fee exposure presented by the PFSs in mediation or the non-binding de novo. Let's talk about the settlement agreement real quickly. We have any questions popping up? I haven't been able to see the chat box yet. Let me just see if there's any questions in the chat box. I want to get to some of those. Let's see. I've got a few here, I think. Here we go. Oh, and Hugo did post the question. Oh, here's a question. What goes into the letter to the other side? We can talk about that in a little bit later. In the letter to the other side, I talk about things like we'd like to settle the case. We'd like to talk about what our defenses are. It's more about the tone and tenor than it is really the substance of it. What we're trying to do is get them to sense risk, a little bit of fear, but not too much, a little bit of doubt over the potential outcome, stress the importance, the time it's going to take, the uncertainty. Those are the calling cards. Those are the themes: uncertainty, delay, ambiguity, time. All those sorts of things are the concepts, almost regardless of the facts. And and you can talk about comparative negligence a little bit, but most people don't really appreciate that too much. You can talk about how the damages aren't as big as they think they might be, and you can talk about things like how much would be helpful to settle the case, and you can express some sympathy in the letter. It's really more about tone and content than anything else, and it can be helpful. What goes in? So, when have I gotten stuck? How did I get unstuck? I've gotten stuck stuck's a funny word. Sometimes you get stuck because there's things going on outside the four corners of litigation somebody hasn't articulated. And I got my monthly blog going out next month. I think one thing I'm talking about is what I call intellectual honesty, which means, are you really being honest with yourself? In the sense of, are you really honestly assessing your exposure? Are you really honestly assessing how much time and effort and money it's going to cost you to get to the end? All right. Are you really being honest about what happened in terms of what your people are going to testify to? Because people have a thought about the case. They think the case is a certain way, and I always keep pushing, but who's going to testify to what? Who are your bodies? Who are your bodies that are going to testify to your case? No matter how much you don't like the other side's case, who are the proponents for your side? And the question I used to ask, who wants you to win? My old law partner says, where's the equity in your position? Always look for the equity in your position. If your position doesn't have any equity and all it is law, you got a problem in the eyes of a jury or a judge. Everybody looks for the equitable result. Everybody looks for equity. If your position has no equity, it seems hyper-technical and nasty and a brutish result, people are going to look for a way to avoid that. So always looking for the equity. Stress the equity of whenever you can in your position. I know that sounds a little silly, maybe, or a little soft around the edges, but equities really kind of matter a lot, particularly in the negotiation stage. If there's no equity in your position, it's really hard for me to get leverage. On the settlement agreement, make sure the confidentiality provisions make sense. Understand that there can be tax implications if you don't put a stated number for consideration in the agreement for the confidentiality. I usually put something like $100 or something like that, or some de minimis amount. Other people don't put any money in there at all, but then there's a risk that you could have the whole judgment or the whole agreement subject to some tax consequences. I think it's more scary in theory than it is in reality, but I think you got to be careful and using a stated amount of consideration is probably helpful. Got to be thinking about Medicare set aside in advance. I did use when I was in practice, I used Medicare set aside specialists, particularly when I knew the case was going to have some significant set aside issues. I got them involved early before mediation to get that process rolling so we know what we have to do. Make sure you check your notes along the way. Here's a little something mediators won't tell you. We forget things. Somebody brings up something early in the mediation, it's kind of sort of important to them, but not hugely important to them. And we're really mostly focusing on the money. If you don't make those non-economic things really important, you don't bring it to my attention, I'm going to tend to ignore them because those things are potential deal wreckers. Like when somebody goes to the homeowners association and says, I want them to amend, I want money, but I want them to amend the homeowners association bylaws to say X, Y, and Z. I know from having done that kind of work, that's a big pain in the ass. It's monstrously difficult. It creates a lot of time and effort. And if you really need it, then it's probably going to blow up the mediation. So I'll tend to put those things to the side. So as a lawyer, you got to be mindful of the fact that you got to really want the non-economics. And if you do, then you got to make sure you check your notes before we do the deal. And those things don't get lost in the shuffle. Most mediators will put the non-economic terms on the back burner until the very end of the case, because we can't agree on the money, the rest of the stuff's not going to matter. The only time that really changes is when you're dealing with things like trademarks and patents and copyrights, and you got licensing and you got going forward issues, or you've got non-competes and you're talking about buying out the non-compete or extending the non-compete, or you've got anti-piracy issues, things of that nature when you're doing former employees under those kinds of agreements. So if you're dealing with IP issues, then the non-economics oftentimes become as important as the economics. And that's, again, where I think some subject matter competency can be helpful to you. And then do non-parties need to be included to reach a durable agreement? And I can tell you, this is one of those, this is that Friday afternoon problem, right? So this is where you do the mediation settlement agreement. You're going to prepare a longer release down the road. Then the defense comes back and talks to the client on Monday. And then the carrier or the client or somebody says, oh, and by the way, I got to get a release for this subsidiary, or I got to get a release for this additional insured on the policy, or I got to get a, and that wasn't discussed during the mediation process. And then you say, I want to release this guy or this entity. And then all of a sudden we got a problem on our hands because we didn't mention them in the Friday afternoon quickie agreement. And now we're trying to get that done on Monday or Tuesday or Wednesday, and we're potentially blowing up the deal. So it's really important that you check your notes, you get your releasees identified during Friday afternoon, not on Monday or Tuesday after we've already signed this little quickie mediation settlement agreement, because you're really then putting yourself in harm's way. So make sure you understand. That's why I say if you bring your settlement documents in advance. Now, defense is going to say, well, wait a second, I don't want to tell the plaintiff about these other entities until I do get a deal done. Right. So you got to sort of play that little dance. You got to play that little game with how transparent do I want to be with the plaintiff during the negotiation stage. Obviously, that's a call you got to deal with, but kind of important when you talk about downstream, particularly downstream vendors, downstream distributors in a products case or something like that. Got to be mindful of those kinds of issues. You're drafting a settlement agreement. What else do you want to talk about? Questions, comments along the way? The end game. So here's a couple of end game techniques that we use when we get stuck. My way for getting unstuck is first to circle back with the clients and talk about things like exposure going forward, cost going forward, risk of appeal, impact on their life. I got a checklist of 4 or 5 things I go back and I circle on and make sure they appreciate, if they walk away from a deal today, how bad things are going to potentially get for them, what the future is going to look like. And then we had the double blind silver bullets. So the way that works is, if I got parties that are, say, $50,000 apart, I got to figure out which of the 2 parties is willing to move the most. And I do a double blind silver bullet kind of a thing is I'll pick a number between the plaintiff's last offer, the defense last offer and the plaintiff's last demand. And if I get 2 yeses at that number, I announce a settlement. If I don't get 2 yeses at that number, you won't know what the other side said. What that process does is it allows you to move off your last best number. And if it settles, great. If it doesn't settle, as we don't get 2 yeses, the other side won't know that you moved. So the way I explain it is, it's like you get the opportunity to jump off the canyon, and if you both grab arms over the canyon and reach a settlement, it's okay. You won't crash and burn. But if you don't get 2 yeses, then the other side won't know that you leaped off your side of the canyon toward the middle. They won't know that you leaped. So that's an advantage of being able to bridge the gap. That's one way I do it. The other thing that I sometimes do is I suggest some sort of alternative to the trial process. And I've been thinking more and more about that. I go, is there one issue we could just litigate with a high-low in place or something like that? Is there one legal issue? Could we do a deal that says, if you're so keen on getting summary judgment, then why don't you put your money where your mouth is and say, if you don't get summary judgment, you're going to pay the plaintiff X amount of dollars within 10 days after the entry of the order denying summary judgment. I look for ways to make the litigation smaller. That's what I try to do, because in most cases you can't afford a full-blown case. You can't afford, there's not enough dollars at stake for full-blown litigation. So, and you've got some issues you just can't negotiate your way through. So what I try to do is come up with some sort of a deal where a order of the court determines the case, or where some issue gets bifurcated, or we just agree to litigate statute of limitations or something like that. Some way to make the things narrower, more compact, so there's not so much to litigate, it's not so expensive, and we can build in some sort of high-low or some kind of contingent result based on what that little mini trial looks like. The other thing I'll sometimes do is I'll separate the clients from the lawyers. I always mention that early on in the process. I say, I may ask the clients to speak directly with each other, or I may ask for attorneys only conference with the permission of the clients. So I tell them early on in the mediation, I may pair you off in different rooms, or I may peel away the lawyers, or I may peel away the clients from the lawyers. But I always do that with the permission of the clients and the lawyers, but I tell them that in advance. So when I suggest that at the end of the day, it's not a big surprise to them. And then there's also blind collection techniques among multiple defendants, where you essentially go around and hang out the hat. And if you get to a certain trigger number, then you notify the plaintiff that you have a trigger number. And then the other thing I need to mention real quickly is covalence and TUMI agreements. Most folks who litigate in the insurance arena understand what that is, but a covalence agreement is where the carrier has failed to provide a defense to the insured, and as a result, the insured is left to defend themselves. Under the old covalence case and its progeny, you can confess to judgment and assign your rights against the insurance carrier to the plaintiff to pursue the carrier directly. You can confess to any settlement that's reasonable, and the carrier will be bound by that settlement as long as there's some potential coverage and the carrier breached the duty to defend. The type of agreement that people don't know, and this will give Stephen a little heartburn, because I guess you are a broker, I guess, right? Are you a 220 agent, Stephen?
Yes, I am.
Yeah, so you'll get a little. I used to do agents and brokers defense, so this will give Stephen a little heartburn. So a TUMI agreement is like a covalence agreement, but it's not as well known. That's where the insurance agent has screwed up, and you don't have the coverage that you think you had or should have had. Like to say the agent didn't get you an umbrella policy and he was supposed to, and so instead of having another $1 million of excess, or you only have $1 million primary. Under a TUMI agreement, you can confess to a settlement within what would have been the limit of coverage, if the policy had been written. And you can confess to a judgment and then assign your rights against the insurance agent and essentially bring a malpractice claim against the insurance agent. And you can, if you're the defendant and your agent did you wrong, you can assign that malpractice case to the plaintiff's attorney and confess to judgment with a covenant not to execute. So it's very similar to covalence, but you're not suing the insurance company, you're suing the insurance agent who screwed up your insurance as a defendant. And it's called a TUMI agreement because there's a case called Wachovia versus TUMI from, I guess, 10, 15 years ago where that was discussed, and it's a enforceable kind of a deal. So I mentioned that because sometimes there are problems with insurance that are created by insurance agents. It's not a big problem, but it does happen more than you think. The other thing I want to mention real quickly while we got everybody here is it's tendering the defense of the claim to the carrier is hugely important. And sometimes there's counterclaims that don't get tendered. And that's one of the mistakes that I run into probably once or twice a year. I'll see a business dispute. Somebody's got a counterclaim filed against them, and the plaintiff, who's now the counter defendant, the plaintiff didn't tender the counterclaim to the carrier, and they would have had coverage for that counterclaim, and they were neglected to tender the defense of the counterclaim to the carrier, and they come to the mediation, and I have the unseemly and not so pleasant task of informing the lawyer that they just committed malpractice because they didn't tender the counterclaim to the carrier, and their client has now spent thousands and thousands of dollars defending a counterclaim that would have been picked up by a CGL policy. So that's a big problem. I don't know, there's no delicate way to bring that up except I peel the lawyer off from the client and I go, did you investigate insurance coverage? Because I think there might be. I don't tell them there is. I say there could be coverage for this, and then you have to sort of let them crawl back into a hole and deal with that problem. That's why I like to have conversations with the lawyers in advance of the mediation, so I find out if there is coverage, and if there isn't, and I think, because I'm sort of a coverage nerd because I teach CGL. So if I think there should be coverage and there isn't, I'll usually give somebody a heads up in advance of mediation if we have a conversation. Sometimes the mediation then gets canceled because they know that they have some homework to do. So I try to protect my lawyers from their own malpractice if I can. If they tell me in advance that there's about the case and there's no coverage that there should be, I bring that to their attention. Okay, so a couple things. Make your plaintiff distinctive, draft a pre-mediation statement and solicit a pre-mediation statement from the other side. If I can't get a demand from the plaintiff's attorney, that tells me he's got client control, he or she's got client control problems. So I'm always asking for a demand well in advance of the mediation, because I want the plaintiff attorney to sit down with the client and talk about the case. In other words, what I'm doing by asking for a demand is I'm creating a little caucus. I'm requiring the plaintiff's attorney to caucus with his client in advance. And if he's got wicked client control problems, it'll become manifest during this pre-mediation caucus. But if there's no pre-mediation caucus and the plaintiff's attorney finds out only on the day of mediation he's got a wicked client control problem, there's not very much we can do about it on the day of mediation. But if we know about it in advance, we can flush it out. What the constant theme I think you begin to see is that mediation is like a dinner party. There's a whole lot of planning that's got to go into the mediation before we get there, in terms of communication between defendants, communication between plaintiffs and defendants, communication over who's going to be in attendance, communication thought about who the mediator should be, given the attendees that we participate, giving everybody a reason to settle, all those kinds of things, flushing out the quote unquote zero pay folks that are threatening not to pay any money. All those kind of conversations are billable if you're in defense, and they need to happen in advance of mediation so you have a fruitful mediation process. We don't want surprises at mediation. And the good news is most of the information you need to effectively mediate, you can learn over the phone. You can just pick up the phone and the other, who you bringing to mediation? What is your demand, Mr. or Mrs. Plaintiff's attorney? What is your demand? What are you looking for? I don't care what the number is, honestly, as a defense lawyer, I don't care. What I want to know is that you had a conversation with your client and then you got a number. I really don't care what the number is because it's not going to influence me all that much anyway. But what it does do is it gives me some belief that you've had that conversation with your client and you have some level of client control. And a lot of times plaintiffs will tell me, I don't have good client control, Dave. And so you need to do the work. And that's my role as a mediator. I need to be the one that gets that. Don't be the first to leave. I don't understand people who, well, I'm out of here. Why would you want to leave? The numbers are only going to get better the longer you stay. You don't be the first to leave. Never be the first to leave. What is that? You're here to settle a case. Be as patient as Job. Be as patient as Job. Sometimes nothing happens for a real long time. And then at the end of the day, people capitulate. People get tired. People say, I want to be done. I've seen it happen many, many, many times. They got all kinds, they're full of all sort of, heat and noise and animosity, and then at 4:30, 5 o'clock in the afternoon, after 8 hours of mediation, they're tired. They want to be done. And all of a sudden, things start to change relatively quickly. Most mediators will tell you mediation starts at 4 o'clock in the afternoon. I think it's true. So don't be the first to leave. And then remember, it only takes one ass to spell impasse. That's the key to mediation theory. Any comments, questions, chat box? Let me see if there's anything I need to cover. I got the CLE number posted in the chat box there. Anything else? Anybody have any questions for the good of the order? Disagreements? Rebuttal? I could be wrong. Okay, I think that brings us to about 1 o'clock. Stephen, thanks so much for participating. I had done one of these kind of tag team deals before, but I think that was really good and useful information and weaves into well to what we're trying to do here, which is get people to be better mediation advocates and protect their clients from unreasonable levels of risk, which is really what we're trying to do. Okay, any other housekeeping, Hugo, that you can think of? I don't have any. Okay, a couple things. So if you want the sample letter that I send, what is a mediation for clients, you can email me, dhenry@henryadr.com. I have that. And I have sample mediation agreements, but you probably don't need that. If you want articles on specific issues related to mediation, there's a whole history of articles that are on my website going back to like 2016 that introduce different topics like opening session, like insurance coverage issues, opening statements, all that sort of thing is covered. And you can get on my mailing list if you're not already on it. Most of you probably are. That's why you're here. You're probably a mediation client or a friend of a mediation client. So you're probably already on the mailing list. But if you're not on the mailing list and you want to be, you can go to my website and click blog and type in your address, and you'll be on the distribution list for future blogs and for future CLE programs that we offer to all our mediation clients.
And David, we have a sample letter as well that attorneys can use to explain what a PFS is, both on the plaintiff and defense side. So if anyone wants to email me as well.
And what's your email?
I think my contact info on one of the screens.
Yeah, I think there we go.
Yeah, there we go. Yep.
There we go.
Just email me there, and I, happy to send out that information.
Okay. Thanks so much, everybody. Appreciate you all attending. Let me just check the chat box one more time. See if we've got anything else. I don't see any other questions for the good. If you have an ethics problems down the road, you run into a problem, you can always reach out, call me. If I can help, I'll help. I've run into a lot of weird problems, so I may have seen your problem before because I've had some weird problems. Thanks again for attending. Y'all take care. We're going to turn this. We're going to conclude the recording now. Thanks a lot.
All right. Thank you.
All right. Thanks, Stephen, for appearing. I appreciate it.
Oh, yeah. Thank you for having me.
Thanks.